It cannot, in other words, merely act on its whims or as a matter of political expediency. The decision of the state is amenable to judicial review. A, the objective of any form of affirmative action, including subclassification, is to provide substantive equality of opportunity for the backward classes. The state can subclassify inter alia based on inadequate representation of certain castes. B, the state must collect data on the inadequacy of representation in the services of the state. The inference in Nagaraj that cadre must be taken as a unit to determine inadequacy of representation, inadequacy of reservation, based on the observations in R.K. Savarwal, in our respectful opinion, is misplaced. The cadre as a unit was considered only for the purpose of preparation of rosters to draw a balance between the reserved and open seats. This court did not hold that the cadre must be used as a unit for the purpose of determining the adequacy of representation. And C, conventionally, the state has assessed if the class is adequately represented by comparing the representation of the class in the services to the total population of the state. However, adequacy of representation, when determined purely from a numerical perspective, without accounting for factors such as representation vis-a-vis posts, would dilute the purpose of the provision. The objective of Article 16.4 is to ensure effective representation of the class in the services of the state across posts and grades. Classes which are socially backward occupy the lowest of the social strata, primarily because of the traditional occupation accorded to the class by social rules. For example, certain Dalit castes are regarded as scavenger castes. Even with the provision for reservation, it is very difficult for the backward classes to shed the traditional occupation that is ascribed to them by society and optimize the opportunities even at the lowest levels. The struggles that the class faces do not disappear with the representation in the lower grades. The endeavor is to ensure true and effective representation of the socially backward classes across posts. Thus, for the above reasons, the holding in Chinaya that subclassification of the scheduled castes is impermissible is overruled. The scope and limits of subclassification of the scheduled castes shall be as prescribed in the judgment. The registry is directed to obtain administrative instructions from the Chief Justice for placing the matters before an appropriate.
Oblate to not.
Just, what's up there?
Go through the erudite and scholarly judgment authored by the Honorable Chief Justice of India. I'm in complete agreement with the conclusions arrived at by the Honorable CJI. However, in addition to the conclusions arrived at by the learned Chief Justice, I also arrived at some additional conclusions to which the learned Chief Justice has also agreed. Therefore, I thought necessary to give my separate opinion. In the beginning, I referred to the celebrated speech of Dr. Ambedkar on 25th of November 1949, the Constituent Assembly, wherein he has said that unless we have a social democracy, the political democracy would be of no use. And then he had warned us about the contradictions in the economic and social plane in the country. I referred to the history as to how the term scheduled caste has come in the Constitution from the original depressed classes. I refer to the census report of 1891, the Indian Statutory Commission report of 1930, census report of 1931, the Government of India Act 1935, and the Government of India Scheduled Caste Order of 1936. I also refer to the repairs in the Constituent Assembly with regard to Article 300A and 300B, which are now Article 341 and 340. I have referred to and analyzed the following judgments of the Supreme Court. This court, in the case of M.R. Balaji versus State of Mysore, State of Kerala versus N.M. Thomas, Akhil Bharatiya Shoshit Karmachari Sangh versus Union of India, K.C. Vasant Kumar versus State of Karnataka, Indra Sani versus Union of India, M. Nagaraj versus Union of India, General Singh versus Lakshmi Narayan Gupta. I have considered the interplay between Article 14, 15, 16, 46, 35, 338, 341, 342, and 366. Before reading down conclusions, I would read some of the observations that I made in my judgment. Para 250, I observed that the basic error that appears to have been committed in EVA Chennai is that it proceeds on the understanding that Article 341 has to do with the reservation of the seats. As already discussed herein above, Article 341 and 342 are only with regard to identification of the scheduled caste and scheduled tribes. Article 341 and 342, read with clause 24 and 25 of Article 366 of the Constitution, provide that those castes included in the presidential list shall be deemed to be scheduled caste and scheduled tribes for the purpose of the Constitution. However, at the cost of repetition, I reiterated that Article 341 and 342 do not deal with reservation. The provisions of affirmative action, including reservation, the matter of public employment, are contained in Article 16 of the Constitution of India. And I observed that, as already discussed herein above, this court in Indira Sahni has held that further classification of backward classes into backward and more backward classes is permissible in law. By that corollary, if a state finds that any of the caste, races, tribes, or parts of or groups within the caste, races, or tribes are not adequately represented, should the state be denied its right to make a special provision for them? I find that, as has been observed by this court in various judgments, it is the duty of the state to give preferential treatment to the backward class of citizens who are not adequately represented. If the state, while discharging that duty, finds that certain categories within the scheduled caste and scheduled tribes are not adequately represented, and only the people belonging few of the categories are enjoying the entire benefit reserved for scheduled caste and scheduled tribes, can the state be denied its right to give more preferential treatment for such categories? In my view, the answer would be in the negative, since the same would not amount to tinkering with the present